All right, now let's talk about federal crimes. USCA Title 18 Federal Crimes. This is another reason why they're covering it up. Offenses classified. Notwithstanding the act of Congress to the contrary, any offense punishable by death or imprisonment for a term exceeding 1 year is a felony. Any other offense is a misdemeanor. Conspiracy against rights of citizens. This is what these judges are involved in. If two or more persons conspire to injure, oppress, threaten, or intimidate any citizen in the free exercise or enjoyment of any right or privilege secured by him by the Constitution or laws of the United States, or because of his having so expressed the same, shall not be fined more than $10,000. They're oppressing me. They've illegally had me sent to jail. They've done everything they can, and they're depriving every citizen of this state that ends up in the family court process, plus the children, of their rights secured by the Constitution. So they are a conspiracy against the rights of citizens. Definitions is used in this chapter. This is a racketeering. New York State Judiciary is a racketeering enterprise. Racketeering enterprise means A, any act or threat involving murder, kidnapping, gambling, arson, robbery, bribery, extortion. These illegal court orders are extorting money from fathers because what they're telling the fathers is either you pay or you go to jail. Either you pay or you lose your driver's license. You pay, you get in arrears, you're not going to be able to get a passport. They're going to take your business license. They're going to take your... That's extortion. They're threatening to take things away if you don't comply with their illegal court orders. Or dealing in narcotics, which is chargeable under state law and punishable by imprisonment for more than 1 year. Any act which is indictable under one of the following provisions of Title 8. Enterprise includes any individual, partnership, corporation, association, or other legal entity. Other legal entity. The New York State Judiciary. And any union or group of individuals associated in fact, although not a legal entity. We're dealing with a legal entity. Stripping people of their constitutional rights. The New York State Judiciary. So it is an enterprise. Pattern of racketeering enterprise. Requires at least 2 acts of racketeering activity. One of which occurred after the effective date of this chapter, and the last of which occurred within 10 years, excluding the period of imprisonment, after the commission of an act of racketeering activity. Now, frauds and swindles under Section 1341 state, whoever having devised or intending to devise any scheme or artifice to defraud, this is what they're doing, they're defrauding fathers of money and mothers, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises, for the purpose of executing such scheme or artifice, or attempting to do, places in any post office or authorized depository for mail, matter, any matter or thing whatsoever to be sent or delivered by the postal service, or takes or receives therefrom any matter or thing, knowing he causes it to be delivered by mail according to the direction thereon, or at any place which is directed or delivered by a person. Mail fraud. The courts use mail. How do they communicate? The judges send their orders by mail. They come to court by mail. They do all types of things by the mail is used. The attorney sending the stuff to the court, the mail is used. You file your papers. A lot of times it's done through the mail. Judge determines a motion. He sends you back through the mail. So the mails are being used. We must interpret the plain language broadly and liberally to further the purpose of the statute, namely to prohibit the misuse of the mail to further fraudulent enterprises. Such an interpretation is totally consistent with the ever-expanding role of mail fraud statute has played. To bring the scheme to use the mails and to bring the scheme into ambit of mail fraud statute, the mails must be used for the purpose of executing the scheme. They are. The court orders are sent. the motions and stuff are all sent through the mail. The mail is used considerably for the scheme. Must be employed before the scheme reaches fruition. That is, because you have to do a lot of stuff through the mails before you're sentenced to jail. Yet, it need not be contemplated as an essential element of the scheme. It's not. But it's the way they do it. So it doesn't have to be an essential element. All it's got to be is used. And they use it all the time. Now, after I was denied several times, I went to federal court. This was Judge K ruling. He raised no substantial constitutional questions. That was Charles. So we filed a federal lawsuit. And there were two judges involved in the federal lawsuit. One was Hurd, and the other was Cholakis. And both of them were involved in several of them. Khan signs off on them. He's the magistrate judge. Cholakis is the senior judge. This was in '94. They did an order and report. Now again, the issues raised was he was denied a public trial, a jury trial. I think those, and there was probably a couple other things, but those were the two main ones. That the hearing examiner who heard it was unconstitutional, that it violated the state constitution. The plaintiff has paid 100 statutory filing fees. The complaint has been filed in this court by several different plaintiffs, and with the exception of the names and convictions specific to each plaintiff, appears to be the form complaint drafted either as a collaborative effort or by a single author. I was the single author. I go through all the damages and stuff. And he even states, plaintiff also seeks to have his immediate release from Albany County Jail and demands a jury trial. For a more complete statement of the claim, reference is made to the complaint herein. Plaintiff may seek damages for unconscionable acts leading to a criminal conviction, but only upon showing that the conviction or sentence has been reversed on direct appeal. That doesn't say that in what I read on the jurisdiction. Matter of fact, the case law is there is no other person. This is what they're doing. Now they're saying you have to show that the state court overturned it. It's a bunch of malarkey. He's in jail. Are called into question by federal court's issuance of a writ of habeas corpus. So now they're saying you have to do a writ of habeas corpus. You know, no matter what you do, whether you do a writ of habeas corpus or a 1983 action, they're not going to hear it. They come up with, you should have used the other method or whatever. He's asking for damages and also the fact, he was suing the attorneys. Where was it? Right here. The judge, his ex-wife, the attorneys, in their official and individual capacity to hear the matter. Does not accrue until, court has pronounced that a 1983 cause of action attributable to unconscionable convictions or sentence does not accrue until the conviction or sentence has been invalidated. In other words, you can sit in jail for lifetime and they don't have the authority, they don't want the authority, they're not going to address it. That's like, you can be stripped of your rights, but the case law says under 1983 and 1343, I think it was, you can get injunctive relief. You can get this. You have the right to go to court for this stuff. Not according to these judges. We got all the way through. Let me just see. And then they tell why they can dismiss it. They make this stuff up. They're supposed to rule in the favor of the plaintiff unless there's no grounds in which he could possibly win. That's not what's happening. They're just refusing to address the grounds. it's properly dismissed. Because the action has accrued, he can't get an injunction, he can't get anything. You need to read these. The problem is when you read them, and then Heard says that the complaint is dismissed pursuant to, for failure to state a claim if the plaintiff fails to submit an amended complaint or objection within 30 days demonstrating his 19th cause of action has accrued due to invalidation of his conviction. He'll never get it invalidated in New York State. He already went to the Court of Appeals in case that no substantial rights were violated. Then you get Cholakis, who comes in and he states, recommends that this court dismiss the complaint. The parties have been served with the magistrate's report. And then he states, after careful review of the entire file, including the magistrate's report and affidavit and memorandum of law, this court accepts and adopts the recommendation stated, and the court agrees with Heard, according to the plaintiff's complaint, is dismissed. What do you expect? And they kept telling how great Judge Cholakis is. Everything says it with his first name. Con. Like in Con Man. He did that with several other people. If you notice, it was in there, the other lawsuits. There was probably 5 or 6 I did for other people that were facing imprisonment or had been imprisoned, trying to get them out and get the convictions overturned. The state courts aren't going to do it because they're not going to address the issues. I had already tried to get them released from jail on a writ of habeas corpus in state court proceedings to no avail. They don't want to address the issues, as the state courts refuse to address the constitutionality of state statute. In the complaint, I raised the issues that the father was deprived of his constitutional right to a public trial, jury trial, and a court, a judge to hear the matter, revocative of his sentence to jail. It was argued that Family Court Act 433, public trial 439, jury trial, or 435, jury trial 439 deprived him of his rights. By order, did Cholakis dismiss the father's complaint, thereby refusing to address the issues of his rights under the law. The federal judges are supposed to protect our rights from state intrusion upon them, as I showed in the beginning, and under federal law. No. You can always find a dissenting judge that they use all the time. That's what they do. In the hallway of the Rensselaer County Courthouse is a sign that states the following. Well, let me state that before this happened, I believe he was deceased or right around that time. And in the paper, his family was saying, oh, he was always there for the little guy. Always there for the little guy. He was there to protect people, and a bunch of malarkey. And this is what I love. The decisions you have made, the lives you have, this is it. The United States District Court judges on Cholakis. Retirement date, June 30th, 96. Well, there he is being wheeled out of the courthouse, and they talk about how great he is. But yet, they don't talk about him depriving litigants of their constitutional rights. The decisions you have made, the lives you have touched, the justice you have rendered will all be part of the history of the Northern District. It was once said, if we cannot maintain justice, justice will not maintain us. You have done more than maintain justice. You have represented the very soul of justice. I'm getting all choked up here. The restored Rensselaer County Courthouse is dedicated this day in memory of Honorable Con G. Cholakis, 2002. To think the Rensselaer County Courthouse is named after this judge is a disgrace to those who have fought for our United States Constitution. As Judge Cholakis deliberately failed to protect the rights of the citizens of this state from the illegal actions of the state court system. He took an oath of office to protect and defend, not cover up the violation of constitutional rights by the New York State Judiciary. He did that in several cases. Not only did he violate the federal Constitution, he was allowing the state to violate the state Constitution. He did not live up. He was a traitor to the United States Constitution, and when he was a state judge and everything else, he was probably a traitor back then too. But he was a traitor as a federal judge to the United States Constitution. He was a terrorist, allowing the state to terrorize people in these closed family court proceedings, depriving them of their constitutional rights. This was appealed to the U.S. Court of Appeals for the Second Circuit. Of course, they refused to address the issues too. Other cases filed to force the federal judiciary to address the constitution of the state statutes and the right to public trials included Berg versus Grissett, docket number 94 CV 1338, Montanaro versus Quarian, Grissett, Borgia versus Quarian. In one of his cases, I don't remember if it was the state or the federal, they came back with, well, they didn't deny that the courtroom was closed. Their argument was, well, there was no proof anybody was denied access to the court. How does he prove nobody was denied access to the court? The courtroom was closed. They knew it was closed. You think they're keeping track? You go in the waiting room. You don't get to go in and sit down in the courtrooms. I'll tell you, I was in Florida. I walked into the support hearings down there. I walked in, sat down, and heard what went on. And I'll tell you, it was very interesting. I went into domestic violence, where they had the men on one side, the women on the other side. Some had attorneys, some didn't, and the others were seated or in jail, and if the ones in jail were going into a box and they could talk to the court through closed circuit TV. But the thing is, everything was open down there. And a matter of fact, when I tell you this, what was funny is after they got done with the attorneys, the first one they brought in was some woman in jail for putting a knife in her, for stabbing her boyfriend. Now, I'll tell you, I did agree with the judge and what he ruled. He let her go on bail. Now you think, why would I say such a thing? I'll tell you why. Because the judge sat there and he said and this is in public, he sat there and he said, does she have any record or anything? Your Honor, she has never been arrested before in her life. She has a completely clean record. What about the boyfriend? Your Honor, he had like a 4-page list. After about 6 items, the judge stopped. Armed robbery. Assault and battery on a police officer. Another assault and battery on a police officer. I mean, this guy had so much assault and batteries with weapons and everything else. She probably was defending herself, which was what she was claiming. And I probably wouldn't deny it, considering the record this guy had of all the things he had done. But it was done out in the public. If it wasn't open, you would think, oh my God, why would the judge let her go? But that was a reason I could understand. But not in New York State. It's all closed. They cover everything up. In Montanaro case, he was the one, I don't know if maybe I'll mention it later on. His ex-wife, he finally found out where she got remarried. He knew there was something wrong. And what happens? They call over Texas. They finally find a newspaper reporter, and then the person says, what has he done now? He was in jail for rape, and he was also charged with indecent exposure to a 5-year-old. But because he pleaded to the rape charge and was sentenced to jail, and they didn't want to put the child through it, they dropped that charge. The court, and then he had a court order that he's not supposed to be around women and children. And New York State, the illustrious family court, thought, nope, she married him, she wants him around the child, there's nothing wrong with it. Would you want this guy watching your 6-year-old son? I wouldn't. But the court doesn't care. We went in there, raised the federal appeal issues. And in the present case, adequate state court proceedings exist in which plaintiff may litigate the constitutionality of the challenged state family court practices. Again, it's being sent back, but it says there is no state court remedy. The state court's not going to address it. He knows this guy's, and then he's got to challenge it after he's convicted, after he's sent to jail. There's no stopping it in the meantime. Cholakis clearly lacked the integrity to address the deliberate violation of the rights of fathers of this state to public trials, jury trials, judges to hear the matters, courts of proper jurisdiction. He is just another judge who talked about protecting constitutional and civil rights while making rulings oppressing them and covering them up, the violation thereof. I should mention that his daughter is a family court judge, and from what I understand, from the fathers I have talked to and have come to see me, she's rude and crude. And her courtroom is closed. But the statute says it's supposed to be open, but they tell me it's closed. You know, they walk in there and they can't get a word in edgewise. It's whatever the mother wants to hear. These courtrooms have to be open. Now, one of the things I will say, she's very hard on, as I said, she's very hard, rude and crude to the men and everything. Why? Now, I'm not a psychologist, but I'm wondering, why does she hate men so much? She's got to hate them if she's always rude and crude. Even one guy that made out well, I said, how'd you make out? How was she when you first? He says, it took a lot of effort to convince her it was the mother. But she was rude and crude to me when I first started, until she realized it was the mother. So, you know, maybe she didn't get along with her father. I don't know. I don't know what he was like. When I did Schufeld's, immediate release from the Albany County Jail, that the court issue an injunction against defendants or anyone acting on their behalf taking against him in violation of his constitutional rights. That this court assume jurisdiction of the as Mr. Schufeld's constitutional rights to a public and a jury trial have been and continue to be violated. You know, we've asked for all this stuff. Also the unconstitutionality of state statutes and everything. He's entitled to relief, but not in New York State's corrupt federal judiciary, which is just as corrupt as the New York State judiciary itself. It's got to end. And one last thing as a final issue. Kathy Jimeno, Rensselaer County Executive, and the Rensselaer County Legislature needs to have that shrine to this traitor, to this terrorist, Cholakis, taken down from the Rensselaer County Courthouse. What he did to the citizens of this state, allowing these illegal practices to continue, of illegal family court proceedings in every county when he could have done something and ordered the jury trials, the public trials, the courts of proper jurisdiction, and address these issues that the state refuses to do, should be removed. Why should there be a shrine to a traitor to the United States Constitution and a terrorist who allows the families of this state, every family that has been involved in the family court process, is not being protected, whether they were there before or they're going to go in there, because of his actions, his refusal to do his job. That is a slap in the face of every citizen in this state to have his shrine in that Rensselaer County Courthouse. It needs to come down, and it needs to come down now. Now, if you want me to bring all the documentation of his court rulings and what was argued and everything, give me a call. I will be more than happy to present everything to the county legislature. All documentation concerning Justice for New York videos can be found at justicefornewyork.com.